Yes, Your Honor. The people call Officer Jacob Lieb.
Okay. All right, officer, raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, you may proceed. Is L-E-I-B?
L-I-E-B.
L-I-E-B. My apologies.
Good afternoon. Could you please state your name for the record?
Officer Jacob Lieb.
Mr. Lieb, where do you work?
I work in Brownstown Township as a police officer on patrol.
How long have you been employed there?
I've been employed at Brownstown for just under 2 years. I've been a police officer for 9 years.
What are your roles and responsibilities in this capacity?
As of right now, I'm a patrol officer on night shift in the Brownstown Township.
Were you working in this capacity on April 10th, 2024?
I was, yes.
And what were you doing that day?
Everything that would entail a normal night shift on patrol, answering calls for service, more specifically.
Could you just move up closer to that microphone and keep your voice up a little bit, please? Thanks.
Yeah, absolutely.
Could you repeat the answer just because it was a little low?
I was answering calls for service most of the night, including the call that we received.
Okay, and you indicated a call was received. Do you recall who that call was received from?
From our dispatch, dispatched me to the Brownstown Police Department station's lobby.
Were you in the lobby at that time?
I was not. I responded there.
And when you responded, did you make contact with anybody?
I did. I'm in contact with our victim in this case, Chantel Sadarski, if I'm pronouncing that correctly.
And what happened when she was there?
So we were dispatched there in regards to a domestic violence complaint. I made contact with Chantel. She informed me that she had gotten into an altercation with her husband.
Object any hearsay.
Any response?
I can withdraw the question. We can
I'll
strike what you
sustain,
said
you can
about.
rephrase. How's that?
Yes. Well, I had asked what happened when she was there.
And he started to say what she told him.
Yeah, so we
So-
can, what he said before that should be,
Well, that will remain on the record, but anything, he didn't really answer it. He just started and she said, and then he objected and I said, I'll sustain it. So you can rephrase your question if you'd like.
okay, I can rephrase the question. That's okay. When she arrived, what was her demeanor like?
She appeared upset.
And did you make a report based off of, or did you make a report that night?
I did, yes.
And was your body cam on and functioning that night?
It was.
Did anything else happen that night?
I interviewed the female, Chantel. I also interviewed the other party involved, Andrew. They both completed witness statements, and I typed a report based off both of their stories.
I don't mean to interject, but one thing I want to say, Mr. Rockeye, you brought the thumb drive with you.
I had it, yes, Your Honor.
So you're just going to retain that. We're just going to know that that's the thumb drive. The exhibits go back to you, but
Yes, sir.
I remembered I told you to bring it today and,
Yes, and I have it.
okay. So that's the way we'll play that. I'm sorry. Go ahead.
I'm just trying to recall. Okay. And did anything else happen after those interviews?
No, I typed my report and submitted it to the Detective Bureau for further investigation.
Okay. Just one moment. Nothing further, Your Honor.
Cross.
Thank you. First of all, thank you for opening the door for me as I walked into the courthouse. I appreciate that. I appreciated that courtesy.
You're welcome.
Officer Lieb, let me, it's pronounced Lieb, correct?
Correct.
And you're in plain clothes, but you have a badge on. So are you a detective now or?
Nope, this is my uniform for court today.
Yes, sir. I'm going to touch on a few different areas and try to get through them as quickly as I can. If I ask a question that's confusing, you just tell me. All right?
Okay.
Now, your answers, have to be verbal. So they have to be out loud as opposed to a nod or a shake of the head. You understand that?
Yes.
You wrote a report in this case, yes?
Yes.
I presume at some point you've looked at it before you actually submitted it? Yes. And I presume that at some point you looked at it before testifying today?
Yes.
You reviewed it today in the prosecutor's conference room?
I did, yes.
Now, there are certain things about report writing that I just want to kind of go through those relatively quickly. There's a purpose in preparing reports, yes?
Yes.
The purpose is to memorialize things that occurred?
Yes.
You try to write it as when things are still fresh in your mind?
Yes.
You try to document things that are relevant and important, yes? And you're trained when you write a report to include the relevant and important facts?
Yes.
And you're trained to write an accurate and complete report. Is that true?
Yes.
And when you're satisfied, and when I started, officers actually wrote reports, but now you guys type them out. Yes?
Yes.
And so when you start typing your report and you finish typing it, you're able to review it. And when you're satisfied that you've discharged your duty to prepare an accurate, complete, and reliable report, you then print it and submit it as your official report in the case. Am I correct?
Yes.
And you did that in this case?
I did, yes.
You also submitted body camera in this case. Am I correct?
Yes.
Now, you had body camera for when Ms. Scardarossi was your original encounter with her in the lobby of the police station?
That's correct, yes.
You have a subsequent body camera with her when you exit to hand her a blank written statement or a statement to fill out?
I would imagine is that on the same body camera?
Well, do you recall if it's the same body camera or not?
If you said subsequent, so I just wanted to clarify. It should be my same body camera, yes.
Yeah, but is it a different actual recording? Or don't you know?
I don't recall.
You actually then made a third recording where you recorded a telephone interaction with Ms. Scardarossi, yes?
Yes.
Objection. He was testifying.
He's asking a question. He's asking a question, leading question. It's okay. It's cross overruled.
Yes?
Yes.
And then you were wearing body camera when you actually went out and spoke with Mr. Scardarossi.
Yes, that's correct.
You reviewed your body camera before testifying today?
I did, yes.
How many different body camera did you review before testifying today?
Just myself.
Just your own?
My own.
The ones that I just referred to?
Yes.
Lobby interaction with Ms. Scardarossi? Yes?
Yes.
Body camera, where you handed her a witness statement to fill out?
If that was included in my body camera, I watched my own body camera from the entirety of the interview in the lobby with Ms. Chantel Sudar-Goski.
I'm just trying
In
to,
other words, what you're telling us, you didn't see on that body cam, you handing her a statement to fill out?
that's what I'm asking you. That was my next question, Judge.
Is that what you're telling us?
I believe. Can you rephrase the question? I'm trying to clarify. I watched my body camera in its entirety from my interaction with Chantel.
I understand. The end of your body camera, what was the last thing that you observed on your body camera with Ms. Scardarossi?
I don't recall.
You just watched it.
I didn't just watch it. I watched it when I was preparing for this case. It was not just a second ago. I don't recall what my last interaction was.
How long ago did you prepare for testifying today by watching your body camera?
I reviewed my body camera footage on Sunday night while I was working.
All right. So I'm going to ask the same question the judge asked. When you reviewed your body camera, did you see you handing Ms. Scardarossi a witness statement to fill out?
I do not recall. I did have her fill one out.
Did you see on your body camera, you handing Ms. Scatarassi a victim notification card?
Objection, Your Honor. Asked and answered.
Yeah, I think it is.
It's a different question.
Wow.
There's a purpose to this last question, if you let me ask it. And saying goodbye to her, like watching her leave the station.
If that was the last interaction, I don't recall if she was walking away or what my last interaction was. I would have handed her a victim rights card with the report number.
I'm just asking if you saw that on your video.
I don't recall.
Preparing. And how about, did you see when you were watching your videos in preparation for testifying today, your interview or your phone call with Ms. Scatarassi that was on speakerphone?
I did see that, yes.
And you saw that in preparation for today?
Yes.
In your police report, you never wrote that Ms. Scatarassi pointed, or that Mr. Scatarassi pointed the barrel of the gun at Mrs. Scatarassi's neck. Am I correct?
That's correct. I did not write that.
You never wrote that Mrs. Scatarassi demonstrated with her finger to her neck the barrel of the gun pointed at her. Am I correct?
Can you rephrase the question?
Yes. You never wrote in your report that Mrs. Scatarassi demonstrated the barrel of the gun pointed at her neck. Am I correct?
That's correct.
In fact, Mrs. Scatarassi told you that the gun was never pointed at her. Am I correct?
You are correct.
And in your report, you wrote, Chantel noted that Andrew kept the handgun in the holster during this incident and never pointed the firearm directly at her. Isn't that what you wrote in your report?
That is correct.
One of the things that you do as a police officer is, of course, when you interview witnesses, you're trying to get information, right?
Correct.
And you're also trying to assess credibility, right?
Correct.
And you pay attention to whether a witness's story changes. Am I correct?
Correct.
And where the witness changes stories or changes the narrative, that could be evidence that the witness is not being truthful.
It could be, correct.
You weren't told, as your report reflects and as you testified a moment ago, that Mr. Scatarassi ever had the barrel of the gun pointed to Mrs. Scatarassi's neck. Am I correct?
You are correct.
You would agree that the neck and the head are two different parts of the body.
That's correct.
Pointed to the neck is different than next to the head, correct?
Correct.
Had the gun been pointed, or had Mrs. Scatarassi at any point said the gun was in any way pointed at her, head, neck, chest, anywhere, you would have noted that in your report. Am I right?
That's correct.
That's an important detail.
That is, yes.
And she never told you that.
She did not, no.
Now, Mrs. Scatarassi, well, strike that. You're aware that Mr. Scatarassi owns a company. Are you aware of that?
They may have mentioned it on scene. I don't know what the company would be, the name of the company or any of their roles in the company.
Well, one way to assess a witness's credibility, particularly in a case like this, is to attempt to corroborate what a witness tells you, right?
Correct.
So in the interview, Mrs. Scatarassi says that she owns a company. Correct?
I don't recall if she says she owns it or she works there or they own it together. I don't recall.
Did you do any research to attempt to evaluate that?
No.
Did you do any checks on Lara or on a state corporate website to see if that's true?
I did not know.
So you don't know if she was lying to you or misrepresenting who owned the company when she interviewed you?
Objection, Your Honor. All of this is irrelevant at this point, whether he did the Lara search and whether or not
Well,
she had
he's
spoken
already
about the business.
testified that he doesn't remember whether she said she owned it, he owned it, or they both owned it.
And I'm asking whether he did anything to determine whether or not
You
she
already
misrepresented
asked
that.
But then you said something about lying. Repeat your last question.
Certainly. You said, you didn't do anything to determine whether Mrs. Scadarossi was lying or misrepresenting her role in that company, did you? That's my question.
Okay, but he doesn't remember what she said. So I'm going to ask you to move on.
Okay.
That's not a proper question.
Okay, Ron. Now, in your report, you repeatedly referred to Mr. Scadarossi's phone as his phone. Yes?
I believe so, yes.
Okay. And Mr. Scadarossi referred to, when she interviewed with you or when you spoke with her, referred to Mr. Scadarossi's phone as his phone, H-I-S, his phone, correct?
Correct.
She never said that his phone was, quote, marital property, did she?
No,
She never referred to it as marital property, did she?
no.
She never indicated to you that, well, it's ours, so I have I can look at it because it's part of the marriage.
Wait a minute.
Objection, Your Honor. Asked and answered.
Sustain.
I think I've made the point. She referred, yes, Your Honor, multiple times. Now, it's important when you're interviewing a witness to actually to be actively listening. Yes?
That's correct.
So when the witness says something, to actually like pause and think, why did the witness use that word, or why did they say that? Yes?
It would be helpful.
Helpful.
Yes.
Mrs. Scadarossi had characterized her conduct to you as vindictive. She used that word vindictive. Do you recall that?
I do not recall that.
Did you inquire for, let me ask you a question. There was a discussion about her sneaking into the home. You were interviewing her and she said she had snuck into the home at night, 1 something in the morning. You remember that?
I recall that conversation, yes.
Does it help refresh your memory about her referring to her behavior as vindictive?
I don't recall using that terminology.
Not you,
Hearing
her.
that terminology. I don't recall.
Okay. Let's talk about what consent means. You're familiar with the word consent or permission, yes?
Yes.
As a police officer, you know consent means that someone is giving you permission or that another person has the ability or has said it's okay to do something, yes?
Yes.
Okay. In regards to the phone, I mean, there's obviously a couple different ways as a police officer to establish consent. I'm going to go through those with you, okay? One is if a person says, yeah, I had consent, like they actually gave me written consent, for example. Yes?
Yes.
Another is if there's actually circumstances that show that the person did or did not have consent, right?
Yes.
Mrs. Scadarossi told you that she did not have consent to access Mr. Scadarossi's phone, correct?
I don't know if she used the word consent, but
Finish your thought.
she told me that she went over there and retrieved his cell phone.
Objection, hearsay,
All right.
Your Honor.
This is actually a prior inconsistent statement because I asked Mrs. Scadarossi these questions, and
So you're just saying you're going to use it for impeachment?
correct, Your Honor. Yes.
Overruled. You are asking a lot of hearsay questions.
So these are all.
They're not all inconsistent statements, so I'll.
Well, the record will bear that out, but I'll make my argument to the court at the appropriate time. She specifically said on the issue of consent, there's no way he'd ever give me any kind of code while he is awake. Remember her saying that?
I believe so, yes.
That's evidence of a lack of consent.
Objection, that calls for a legal conclusion.
Any response to that?
What's that?
She said that calls for a legal conclusion.
I don't know that it does, but I'm asking for the officer's assessment. So,
He's not a lawyer. I'm going to ask you to move on.
Okay.
Stay in the objection. If you answered that, I'm striking it.
she never said to you, I had permission or I had consent to access his phone at while he was sleeping at 1 something in the morning, did she?
No, she did not.
And she indicated to you that they were separated, but marital separation.
No.
Okay. Tell me about his computer. What did she say about his laptop?
Your
I don't recall.
Objection. Irrelevant.
Well, it goes to, it's impeachment again. Goes to prior inconsistent statement.
Well, you got to be more
I'll
specific.
be more specific. She never even
Well, I'm
mentioned,
asking you to be more specific with what statement that's.
Oh, sure.
that
sure,
Well, she never denied that she,
you know what, I'll withdraw and I'll rephrase it to make it easier. In your interview with you, Mrs. Scardarossi never said to you, so by omission, she omitted sharing with you that she'd attempted to access Mr. Scardarossi's laptop in his home that night. Am I correct?
I don't recall. She attempted to retrieve a passcode from his cell
On
phone.
his cell phone.
Yes.
She never told you. You have no recollection of her telling you that she attempted to access his laptop. Am I correct?
I don't recall that.
Would you agree that if she had indicated that you made reference to the phone in your report,
Yes.
correct? There's no reference to the laptop in your report. Isn't that true?
That's true.
And had she told you that she tried to access his laptop, that would be something that you would have put in your report.
Depending on if it was if she removed it from the home or if it had anything to do with these allegations, it would have been noted.
Okay. All right, I want to focus for a second on one more issue with Mrs. Scardarossi, if I could. So, between 1:40 and about 1:50 was your first conversation with Ms. Scardarossi in the lobby of the police department. Giving you a time frame, about 10 minutes. Yes?
Is that a question?
Yes. That's a
Yes, it sounds pretty accurate.
During that interaction with Mrs. Scardarossi, she never said to you that she disabled any of the security cameras in the home. Am I correct?
You are correct. She did not tell me that.
Your second conversation with Ms. Scardarossi was between 2 o'clock and 5 seconds or so and 2:09, somewhere in that range, about 9 minutes.
That sounds accurate.
She didn't mention it the second time either, did she?
I don't believe so, no.
We asked her to write out a written statement. Yes? Or if she was willing to write one out.
She was willing and she did, yes.
Now, you don't tell people what to write in their written statement, correct?
Correct.
You don't tell them to conceal or omit facts, do you?
I do not.
You don't say, look, just put part of this in there, but anything that may look bad for you, feel free to leave out. You would never do that.
No.
And if I were to say to you that there's a claim that you told Mrs. Scardarossi not to include any reference to the cameras being disabled, you would say that's false.
I would say that's false. Correct.
And if I were to say to you that Mrs. Scardarossi or someone, there's a claim that you told her to just exclude certain information from her written statement, you would also say that's false.
Correct.
Now, as Mrs. Scardarossi was leaving at about 2:37 in the morning, so we're now about an hour or so into your interaction with her, she's still at the police station. And as she's about leaving, there is a discussion about the interior kitchen camera, correct?
I don't recall.
Okay. At that point, prior to her leaving the police station, she never mentioned to you that she had disabled the front door ring camera, correct?
That's correct.
At 3:41, now at 3:41 in the morning, you call Mrs. Scardarossi on the phone, yes?
Mr. Scardarossi?
Mrs. Scardarossi.
Mrs. Scardarossi, I did contact her.
Now, this is 2 hours after your first interaction with her.
Yes.
After multiple interactions with her in the lobby of the police department, yes?
Yes.
And after having gone out to the scene and speaking with Mr. Scardarossi, am I correct?
Correct.
And you return, and Mr. Scardarossi had shared some information with you. He had shared some Ring camera videos with you.
Correct.
You got information from him about the Ring camera videos that Mrs. Scadarrasi didn't tell you about.
That's correct.
If I were to ask you, if someone said, well, Mrs. Scadarrasi told you about the disabling the exterior camera at the house, at the police department, that would just be untrue, correct?
Correct.
You called her on the phone, yes?
That's correct.
And you put her on speakerphone, right?
Yes.
And you had a purpose in calling her, right?
Yes.
And the purpose in calling her was to question her about information that you got from Mr. Scadarrasi, specifically about the Ring cameras that she didn't tell you about.
That's correct.
And you confronted her about, one, why didn't she tell you, right?
That's correct.
And you confronted her about why she disabled the exterior camera and why she disabled the interior camera.
That's correct.
And one of the things that you do is when you investigate a case is you're obviously looking for evidence of the allegation of the alleged crime. Yes?
That's correct.
When you were speaking with Mr. Scadarrasi, this is a question that he asked you. He put the question, you had said, well, you had already talked to her and you'd already talked to Mr. Scadarrasi. Yes?
I don't recall if he asked that question or not.
Well, let me see if this refreshes your recollection. If not, I can go to the video. He inquired of you, what did she say happened? What was her version? Remember that question?
I do not recall him asking that specific question. If he did ask it, I don't recall.
Do you remember actually explaining her version to Mr. Scadarrasi as, quote, it's out there, unquote?
I don't recall.
When you used the phrase, it's out there, I mean, have you used that phrase before?
Objection, asked and answered.
I don't
Your Honor.
recall.
He said
Wait a
he
minute.
used it. Would you like me to repeat?
Yeah.
I said asked and answered. He had already said that he never used that phrase.
Sustained.
Okay. I don't think
You want to rephrase? Go ahead.
Sure, I'll be happy to. Have you ever, in the course of your, how old are you?
31.
In the course of your 31 years, have you ever heard that phrase in just common jargon, like it's out there?
Objection, Your Honor. None of this is relevant.
I disagree. He's investigating the case, and I'm going to lead up to the point. I'll make my offer of proof.
Go ahead.
He literally told Mr. Scadarrasi that which I'll play on the video in a moment, that Mrs. Scadarrasi's version was, quote, it's out there, which I believe is a reference to it's so strange, it's so out there, like bizarre. And then there was a further discussion later on where...
Listen, I'm going to let you ask that question, but you're really asking, I mean, I've been sitting here and she's not objecting. You're really asking for a lot of hearsay, both ways.
This one is hearsay? Okay.
Well, yeah, if he's saying, he's repeating what she said, it's out there.
Oh, he's saying, that's his statement.
It's out there.
It's out there. Like to characterize...
Ask this question, but I'm
Yes.
just telling you, you're going through a lot of hearsay.
Okay, Your Honor. The phrase "it's out there," you understand, you've used it or heard of it in just common jargon. You've understand it to be used as bizarre. It's something that's strange.
I think that it could be interpreted as one way that you could use that word.
Which way did you lean it?
I don't recall saying it in the first place.
Okay.
You thought her account was strange.
Objection, speculation, Your Honor.
Well,
That's fair.
that's
I
not
would try.
speculation, but it's argumentative.
I would try. There came a point further where you were talking to Mr. Scadarrasi and you were discussing what evidence there was that you had gathered in your investigation about, I'm talking about you now, of either his account or her account, correct?
Correct.
And is it true that you said that there was no evidence? I'm just asking about your statement to Mr. Scadarrasi. So you said there's no evidence of Mrs. Scotarassi's claims. Isn't that what you told Mr. Scotarassi at his house?
I don't recall.
Did you ever check, one way to attempt to verify at least part of her account was to check her computer for spyware? Right?
Are you asking me?
Yeah, I'm asking you. And she complained of spyware being on her computer.
Objection, Your Honor. It calls for hearsay.
I'll withdraw. Did you investigate whether Mrs. Scotarassi's computer had any spyware on it?
I did not know.
How do you know that she wasn't searching for financial data in the course of her separation from her husband?
Objection, Your Honor. That calls for speculation.
I'm asking, how does he know?
That calls for speculation. It's not relevant.
Okay. Well, let's go to this. So another way, you understood that there was a claim that Mrs. Scotarassi had taken Mr. Scotarassi's money from his home, correct?
Correct.
And Mr. Scotarassi's firearm, correct?
Correct.
You didn't search Mrs. Scotarassi's clothing, pockets, or anything else to check if she had money on her, correct?
Correct.
You didn't search her pockets, didn't search a purse, you didn't search her vehicle, correct?
Correct.
I recognize that you could have sought different ways to have searched any of those things to look for evidence corroborating Mr. Scotarassi's claim that she had taken the money.
I know, but you're still talking about hearsay.
What's the hearsay?
How is that?
I'm asking if he did anything to corroborate.
Mr. Scotarassi, you're referring to statements that Mr. Scotarassi's made, right?
I'm past that. I'm now referring to whether an investigation, did he actually conduct any investigation? Didn't search her pockets, didn't search her vehicle, didn't search Mrs. Scotarassi's purse. Did you search any of those things?
Wait a minute.
Yeah.
You're really filling this thing with hearsay. I'm not saying anything. The prosecutor isn't objecting. When you're asking him about statements that he makes, unless there's an exception, it's hearsay. If you're asking what your client stated, unless it's admission against interest, and I know you're too good to ask those kinds of questions, it's hearsay unless you have an exception. I'm just asking you to move on. Okay?
Okay. I'm not dealing with hearsay here, Your Honor.
Well, you've been dealing with hearsay. If you haven't asked at least 20 questions that call for hearsay in the last 35, then I don't know what I'm doing.
Well, I beg to differ, but I'll
Ask your next question.
Sure.
We'll take it one at a time.
Did you search Mrs. Scotarassi's vehicle?
I did not.
Did you search Mrs. Scotarassi's phone?
I did not.
Did you search Mrs. Scotarassi's? Did you do any investigation at all of the path between let me back up. The path between Mr. Scotarassi's home and the police station? Did you go look at that path?
The route she drove.
The route she drove.
I did not.
When you arrived at Mr. Scotarassi's home, you sought to interview him. Am I correct?
That's correct.
He cooperated with you?
He did.
He spoke with you and agreed to write a written statement. Am I correct?
He did. Yes.
You never searched Mr. Scotarassi's home for a gun?
I did not.
Never searched Mr. Scotarassi's home for the money that was reportedly missing?
I did not.
Never searched Mr. Scotarassi's vehicle for the gun or the money?
That's correct.
What my point is, who reported that the money was missing?
I didn't ask that question.
Yeah, you did. You said you didn't check for the money that was reported stolen. Reportedly stolen. So where did that come from? It had to come from somebody. He wasn't there. There's no evidence he saw it on the camera. Somebody had to ask the question. Somebody had to make the statement. And it's hearsay. Or it's a lack of foundation, or both. Okay? Can we move on?
Judge, may make my record. Humbly and respectfully, I disagree. I think that there's no evidence in this case of the allegations that Mrs. Scadarrasi made against Mr. Scadarrasi. I believe that not only is there no evidence of it, but I believe that Mrs. Scadarrasi's credibility is nil.
I understand where you're going.
And I believe that I'm entitled, in fact, I would say that I'm duty bound to follow up with what investigation the police did to investigate whether Mr. Scadarrasi, whether the money was missing, whether there was a gun, any of the things, that Mrs. Scadarrasi happened to claim. Remember, she denied taking his money. She denied taking the gun. She wasn't, and she testified to that, as I recall. She wasn't searched. Her vehicle wasn't searched.
I don't remember hearing her ever say that there was, the only time I ever heard anything about anybody saying that there was an accusation of money being stolen was that she reported that when she was testifying that that's what your client said. You stole my effing money is what she testified to, as I recall it, which would be deemed an admission, right? It's against his interest. It's not in support of his interest.
It's against his interest to claim that she stole his money?
I'm saying that there was a reason why you're not going to object to hearsay. That is not hearsay. If the prosecutor's introducing that statement, as she did on direct, that's not hearsay. We know. I mean,
I'll share with you my recollection. My recollection, again, this is my recollection. My recollection is that Mrs. Scadarrasi she testified on direct examination and testified on cross-examination that she didn't take his gun and that she didn't take his money. And I believe that I'm not only is it important and relevant, but I think I'm duty bound to ask this detective, this officer, when you interviewed her, did you just took her word for it? Did you pat her down? Did you look? Did you examine her? There were conversations about the money and the gun.
Why don't you ask the next question? And we'll go from there. Go ahead. Ask your next question. I mean, I think you pretty much established he didn't do any of the follow-up that you think he should have done. He didn't go and check for the spyware. He didn't go and search for the gun. He didn't investigate whether or not money was stolen.
What's the reason? What's the reason? And I appreciate that, but for purposes of the case,
because you're saying it goes to her credibility. I get all that. I'm just saying you've established all of that, don't you think? I mean, which aspect of that?
I hope so. Okay. I hope we've established it. So, ring cameras are something that police officers are now forced to or are accustomed to dealing with on a regular basis. Yes?
That's correct.
Did you go to any of the neighboring homes around Mr. Scadarrasi's home and check if they had any ring camera showing Mr. Scadarrasi entering or leaving the home?
No. To clarify, his ring camera shows her approaching the home and entering.
He has neighbors.
Yes.
I'm talking about the neighbors.
No.
Shows her entering the home. Yes?
It shows her approaching the home.
Approaching the home.
Then the secondary camera shows her inside the home.
Yes. I'm talking about.
We did not go to the neighbors.
Neighbors to see whether she was walking out with something in her hands, or whether she was walking out with a gun, or walking out with money, or walking out with anything, or walking out barehanded. Right?
That's correct. We did not.
You've responded to domestic violence calls in the past, haven't you?
That's correct.
And you understand that where there's reasonable cause, as a police officer, reasonable cause to believe that a crime of domestic violence occurred, you can make an arrest of the alleged perpetrator, correct?
Correct.
Despite Mrs. Scadarrasi making her claims to you at the police department, you did not go out and arrest Mr. Scadarrasi on that date. Am I correct?
That's correct.
Mr. Scartarossi did not evidence any physical injury. Am I correct?
That's correct.
Apart from her word, there was no evidence of her allegations. Am I correct?
That's correct.
Have a second, Chairman.
Sure.
Thank you. Nothing else, Your Honor. Thank you.
Thank you. Redirect?
Yes, Your Honor, briefly.
I'm going to ask a question, a couple questions.
Yes.
You said you looked at the tape of the interview between you and her in the lobby of the police station.
I did.
You
That's
did
correct.
that on Sunday night, 2 days ago? Is that to understand correctly?
Yes.
When I watched the video, when Mr. Rockine played that video, I was a little unclear as to where she was pointing to.
Correct.
You testified she didn't indicate to you in a written statement that he pointed the gun at her.
Correct. According to her, it stayed in the holster. He grabbed her with his left hand by the hair and raised the firearm near her head. She told us that she did not point at her. He didn't point it at her. He raised it up near her head while he was holding her hair.
Go ahead.
And I want to ask you about what you just said to the judge there. You said that she said he didn't point it at her.
That's correct.
Did she say that it was next to her head?
She said he pulled it up near her head and then did a motion of the firearm or
Keep your voice up.
She said that it was not pointed at her. It was near her head.
So you stated that on cross, you stated that you documented in your report that the victim told you that the gun was never pointed at her. Is
Correct.
that correct? Okay. But did you document in your report what the victim stated happened with the gun?
Yes.
And during your interview with the victim, with the complaining witness, did she demonstrate to you what had happened with the gun?
She held up her arm like this.
And describe for me what you're doing right now.
I'm holding a fist where I was assuming that she was showing how he was motioning with the firearm in his hand.
And Judge, just for the record, because we can't see.
Yeah, you have to describe it. So you've got a closed fist somewhere about 3, 4, God, I don't want to put words in your mouth.
Right.
3, 4 inches from the right side of your jaw, correct?
Correct. So she said his left arm. Would you like me to stand up?
Yeah,
That'd be easier.
stand up and demonstrate it the best that you can.
According to her, he had her hair with his left hand, with a holstered firearm, was making statements and holding the firearm near her head.
Okay, and right now you're about 10 inches with your fist, which I suppose you're trying to describe as being the firearm.
Correct.
From the right side of your jaw. Is that true or false?
I'm just saying, he's
I want you to tell me.
in the middle of this.
I don't want him to say it. I don't want me to say
it. Whether it was right here or farther out.
And right here, you said you had not near the temple, and then you pulled your arm back out about another 15 inches, true? At one point, you said she had her hand up here, and you had it by her temple. Correct me if I'm wrong. If you want to redo it, I want it. It has to be described here. And then you pulled your fist away, and it was about 18 inches from 15 inches, I would say, from your head. Is that true?
That's to the best of what I recall of her telling me the events of it.
So somewhere between 2 inches and 15 inches.
Yeah. Roughly. I mean, she said it was right up next to her head.
Okay,
Next to, I guess, could be interpreted, 2 inches, 15 inches. I think in the realm of if she was holding her hair, I would imagine it was closer rather than farther away.
The only thing I just want to add, if I could, to the visual demonstration. He has his fist, what looks like to be like around I presume it's supposedly holding the gun. But the side of the gun would be to the side of her head, not the barrel ever pointing at her, which is why he wrote the barrel was never pointing at her.
That's correct. She said that he never pointed the gun at her.
okay.
Thank you.
On cross, you stated that there was no other evidence besides her allegations. Did you direct her to make a written statement?
I requested if she would like to make one, or I asked her if she would like to make one, and she did.
And is a written statement considered evidence?
That's correct. It could be, yes.
Okay. And did you document in your report whether a threat was made or not?
I did, yes.
Sorry about that. And then I asked you about your report, and then during the interview, did you report that there was a threat made?
I did, yes.
And typically, when you make an arrest, do you typically arrest every individual accused of domestic violence?
No.
Just one moment. Just a few more questions.
Take your time.
When she had demonstrated to you what had happened, did she demonstrate what had happened before she had walked into the police station?
No.
Let me rephrase that question.
I didn't even understand it. What do
Yeah.
you mean, at what point? You're saying, did she demonstrate what happened before she got there? What do you mean, the whole day, the week, the
I
hour
will
before?
rephrase the question.
Okay.
So I apologize for that. So you just demonstrated what she showed you with the gun. Did she report that any threat was made when that was happening?
I'm object to hearsay, Your Honor. It's not a prior.
Well, I think you already answered that.
Your report, you testified that it was in the report.
It was in the report. Okay, so you're asking now, did she indicate whether or not there was a threat made?
Yes.
And you're objecting on the basis of hearsay?
Yes.
Did you have any response?
He did just demonstrate to us what she said and
You
how.
can establish foundation for sure if you want to try to do an excited utterance. If you don't, you don't. If you can't establish the foundation, then I'm not going to let it in.
I can establish the foundation, Your Honor. When Ms. Gardarasi entered the police station, and she made a report, to your knowledge, was that report made? How much time had happened in between the report and the incident that was reported?
I believe roughly about a half hour, maybe a little less.
And how did she appear to you?
She appeared upset. I think she was attempting to hold back tears while she was explaining the situation that had just occurred.
Did she cry at all?
I believe she was wiping away tears during our entire encounter.
And when she had come in to make the report, did she indicate to you that a threat had happened?
I object to hearsay.
Did I believe I established foundation there.
I disagree.
I'm gonna allow it. I mean, I observed her, and for the record too, the tape that was played certainly showed she was under the stress or excitement of the startling event or condition. So I'm gonna ask you to answer that.
Okay, can you rephrase the question for me?
Did she indicate to you that a threat was made?
Did she
During the
indicate
incident.
whether or not a threat was made to her?
That's correct, she did.
No further questions, Your Honor.
Any recross?
No.
You can step down. Thank you. Call your next witness.
Your Honor, the prosecution rests at this time.
Okay. You move the bind over?
Yes, Your Honor. If I may.
Sure. Unless you want Mr. Rockine to argue first, and you can rebut it. It's up to you, whatever you want to do.
I can argue now. Your Honor, I want to kindly remind the court that the charges being considered here for bind over are assault with a dangerous weapon and felony firearm. For an assault with a dangerous weapon, the elements required are first that the defendant either attempted to commit a battery on the complainant or did an act that would cause a reasonable person to fear or apprehend an immediate battery. Second, that the defendant intended either to injure the complainant or to make the complainant reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have that ability, or thought that he had the ability. And fourth, that it was committed with a dangerous weapon, which, as we know, is an object that is used in a way that is likely to cause serious physical injury or death. In this case, it is a gun. We heard a lot of testimony over the last few days that this exam took place, but the complainant clearly testified that her ex-husband, the defendant, threatened her by putting a gun to her head, showing us exactly how he did it, and that she was placed in fear for her life due to his actions. We saw the body cam footage that shows her fear and panic. We saw her speaking to the police officers almost immediately after the incident had occurred. And it shows exactly how she described it to the police officers, which was consistent with her statement on the stand. Everything that happened outside of this incident, all of the additional circumstances, would just be smoke and mirrors. The reasons why the complainant wanted the laptop password, how she attempted to do it, are all extrinsic factors that will be questions of fact for the trier of fact. The complainant was truthful and credible. She was consistent in her statement here and consistent in statements to the police. And it's important to remember that there's a probable cause standard here. And based on the elements of that assault by a dangerous weapon and the felony firearm that attaches, we believe that the elements have been satisfied and move for a bind over as charged.
Thank you.
We paint an alternative picture, or at least draw the court's attention to an alternative picture that comes from the facts of the case. Woman tells the police that she moved out of her home and she's been out of the home for a week to 10 days. She goes to the home like a burglar, sneaky, dishonest. She goes to the home at 1:40 or so in the morning, 1-something in the morning. Doesn't walk up the walkway, but actually walks up the side through like a burglar, like a stalker. Walks up the side of the home, through the landscaping, through the grass, and actually attempts to sort of sulk, hiding herself by a camera, disables an exterior camera so that can't be seen when she actually enters the home, comes into the home, doesn't announce that she's coming, doesn't tell anybody that she's coming over, doesn't seek consent or permission. Quite candidly, there are circumstances where a person who entered into a home at night, even if they believe they had the permission to be there, could be deemed a burglar or someone that was engaged in a home invasion by the homeowner. There are people that if they were asleep and heard someone that they didn't expect to be in their home, would and could have taken action against someone who was engaged in what certainly sounds and looks like a home invasion first degree, entering into a home with intent. An intent to commit a crime inside, to commit a crime within, to commit a felony within. And once inside, they knew or know, or it turns out that a person was inside the home. That's a home invasion first degree. They can call her the victim all they want. Quite candidly, when this exam is over, regardless of what happens, we're filing a police report against her. The best thing that happened in this case for her was when Your Honor appointed her a lawyer. The worst thing that happened to Mrs. Scaterassi in this case was when either the prosecutor gave her some sort of permissive, although unspoken, promise that we don't think she needs immunity, or her lawyer or someone advised her that she shouldn't seek to assert a privilege because she admitted to multiple crimes on this record. And one of the most dishonest acts I've seen by a complainant or a complaining witness or person in I don't know how long. But I digress. Inside the home, and we'll get to her credibility in a moment, she takes a phone that she has until the second preliminary examination date identified as his phone. Told the police it was his phone. Told the officers it was his phone. Wrote it was his phone. The first day of testimony referred to it as his phone. Took that phone and then attempted to gain access to it without consent or without permission. Whatever person, whether it be on WikiLeaks, whether it be a friend, whether it be a kind detective who knows a friend, whomever gave her the idea that she should come in and testify the second or third time she was here, or the second time she was here, and say that that was marital property when she never characterized that before, did her a disservice because it was a lie. My biggest fear in this case is that the court won't find that she lied and will somehow find that her claims are credible, because they aren't. But she takes the phone out of the house. She goes down the street. She drives down the street. She then attempts to access the phone, which is another crime. Then she drives the phone back, comes into the house. There's an argument. There's absolutely no evidence whatsoever that what she says took place. There's no evidence that he pulled a gun. There's no evidence that he displayed the gun. There's no evidence that he brandished the gun. In fact, were the court to take a look at the video of the video that was played showing Mrs. Scaterassi in the kitchen when she crouched down and hid, although she testified she didn't crouch down and hid, when she testified that she didn't beckon the dog over, although the video shows her beckoning the dog over, that when you look at Mrs. Scaterassi in the home, Judge, take a look. Remember, she testified that the gun, when she entered into the home, was actually on the kitchen counter or on the table. Look. We played the video. The court recalls the video. There was some interesting exchange between the court and the prosecutor about 421 versus 422. Clearly, you weren't referring to the time of day. You were referring to the time on the video. I know you remember that. I remember that because we saw Mrs. Scaterassi. You can see in the kitchen, there's no evidence of a gun on the counter. And the police didn't search Mrs. Scaterassi for it. The police and Mr. Scaterassi, as we could tell because Mrs. Scaterassi said this, there was some question later on. The police questioned her about where the gun was. But never did they actually do any kind of search for evidence in this case. Mrs. Scott, there's an argument. There's a discussion. These are facts now. Put aside, Mrs. Scaterassi leaves. She's in the middle of a separation from Mr. Scaterassi. She has a divorce lawyer, which she admitted to us. She'd already consulted with her divorce lawyer before this happened. There's a business. There's a dispute over a business. And I addressed some of that with the court. And then she's busted breaking into the house by Mr. Scaterassi. Busted. Like he catches her. She then goes to the police department and it comes up with this story for which there is not a single shred of evidence. No gun, no money, no wound, no injury. What do we have? We have Mrs. Scaterassi's testimony. Did she act like a person who was trustworthy when she went to the house that day? Take a look at the video. Does an honest person enter into the home by disabling the exterior camera? No. Does a dishonest person traipse through? Does an honest person traipse through their landscaping? No. You could see, and she wanted to quibble with me over how she went about trying to remove the camera. You can see her up against the side of the wall trying to remove the camera, and then it's gone. We would see what happened inside if something had happened if she hadn't disabled the cameras. What a perfect ruse. Take my word for it. There's no evidence, but take my word for it. Even though I disabled the cameras, that could have provided evidence of me leading with the gun or not, as Mr. Scadarrasi claimed, leading with the money or not, as Mr. Scadarrasi claimed, or this allegation of a violent assault or an allegation of an assault for which there's no evidence. We would see whether that occurred or not, but we can't. So what do we have? We have Mrs. Scadarrasi's word. Let's break down her word. She testified here on her oath. I specifically asked her that, on your oath, did you tell the police when you were at the Brownstown Police Department about disabling the exterior camera? Does the court recall the answer? I do. She swore that on her oath that she did. She swore she had seen the body camera. I know it's there. I know that it's on the camera. I know that that's what I did. I know I told the police that, she said. Except we have the officer who has no stake in the outcome of the case, who literally says, no, she didn't. He had to call her 2 hours later after learning from Mr. Scadarrasi about the exterior camera being disabled to actually call and question her as to both why didn't you tell me and why did you do it? That's dishonest. 2, she didn't disclose to the police that she had, when she was in the lobby, disclose to the police the disabling of the interior camera. That came 2 videos later. She didn't disclose to the police. She didn't include any of those facts in her written statement, which we admitted for purposes of impeachment as a defense exhibit. I questioned her about that. She conceded in her written statement, and then what she did is she said, well, the police officer told me not to include those things, to just include certain things in my written statement, and I'm paraphrasing. I asked Officer Lee, did you tell her to admit anything? He says no. Of course not. Another bit of testimony that wasn't true. She testified that he pointed the gun at her neck. I mean, I know the court recalls that testimony. She swore again on her oath that, one, she was very clear. I'm going to use right hand because that's my dominant hand, but she was very clear. Does the court remember how she did it?
Of course I do.
Right. She said that she had her finger, wasn't hard. It's like you do as a child. Remember when we're playing guns and cops and robbers? No offense to the cops. Cops and robbers, or and you have a gun and you use your finger as the barrel. She was very able here in court to demonstrate. And she said that took 2 fingers or 1 finger and held it to her neck. I'm not using the correct side. I understand. I'm just demonstrating. She was to my neck, pointed. And she went to the point of trying to tell us that the gun wasn't, that when she was, well, when I said directly pointed, I was just talking about pointed from afar, not pointed close. Also, we have the officer here testify. What did you put in your report? Never pointed the gun at her. Did you write that the pointed the barrel of the gun at your neck? No. Did she demonstrate that the barrel of the gun was pointed at her neck? No. Did she demonstrate with fingers shaped like a gun that the gun was pointed at her neck? No. Did you write never pointed the gun at her neck? Yes. Had she said that the gun was pointed at her neck, not beside, this allegation of being beside her head, but had you been told that, would that be a fact you put in your report? Yes, because it's an important fact. Not her testimony in court last time and previously was untrue. That's untruthful testimony. What should the prosecutor have done with all due respect to her? She should have pulled the plug on this case at that point. To stand here and make a claim that the witness was credible, that her story was consistent, without breaking down the details of the case, does a disservice to any witness who's coming here and attempted to be credible and deserves the moniker of credible and consistent. She was anything but credible and anything but consistent. I can break down even more. She testified Said, oh, I thought it was marital property. She didn't testify to that. That was her testimony last time. That was after the court had advised her that you were going to appoint her a lawyer, and that she had time to consult with her lawyer, and she had time to talk to the prosecutor, was her testimony, and that she had time to talk to some friend of hers who was a lawyer, who we don't know who that person is. I don't know if it's a divorce lawyer or the guy at the end of the bar that just happens to be a lawyer. I don't know. Who knows? We have no idea. Don't know who that person is. Could be something she read online. I don't know. We don't know. But she used the word his phone, all throughout her discussions with the police as the officer conceded. But then when, after the court appoints her a lawyer and she talks to somebody and she knows that she's in potential criminal jeopardy, she actually says, oh, I thought it was marital property. So let me get this straight. The credible, reasonable explanation is that you broke into a house after disabling the cameras like a burglar, and you then took the phone that you thought was marital property off your husband's sleeping chest, your soon-to-be ex-husband's sleeping chest, and you left with it. You took it out of the house. I mean, it's preposterous. The story, I mean, quite honestly, I sat there and thought, man, she should plead the fifth. To be frank with you, I'm pleased that she didn't, because I've got a record. So we've got his phone and the change to, I thought it was marital property. We've got a claim where she, of course, didn't have consent. She concedes she didn't have, the first time we testified, of course she didn't testify that she didn't believe she had consent, and I'm paraphrasing again, or permission to access his phone. She didn't have permission to go into the computers after hours at his work to attempt to access the computers at work. Another dishonest act. I'm going to tell you, any one of us had a spouse or ex-spouse that was going to our office or to your computer or phone trying to do it at night. You would be like, what are you doing? That's a crime. I mean, it's criminal. Says she tried to access his laptop too. Never referred to it as marital property anywhere, except after she's facing potential jeopardy, her answer changes. She told the police, she testified before you, sworn her oath, that she told the police about disabling the cameras. We hear today, that's not true. So when someone omits something or conceals something important, particularly something that puts them in a false or negative light, that weighs on their credibility. And I would posit to you, Judge, that Mrs. Scartarassi's credibility is zero. When I asked the officer the question today, when I asked him specifically, is there any evidence? Because that's what the police are supposed to do in theory, right? I mean, they're supposed to go out and attempt to collect evidence. The court questioned me about why I was getting into hearsay and why I, at the end of a sentence here or there, or that. But that's what the police are supposed to do, is to attempt to gather evidence. Either evidence, they had plenty of evidence that Mrs. Scartarassi had committed crimes, plenty. And I would posit to you, with all due respect to Your Honor, with all due respect to the Brownstown Police Department, and with all due respect to the prosecutor's office, were the tables turned and a male had done this, and a female had made the claim, and a man who had moved out of the home and during the course of a marital separation, that the man went into the home and that this had happened, I suggest to you, Judge, that things would be much different. There is no way that man would not, under those circumstances, I cannot think of a circumstance in which the tables were turned that the police would be treating Mrs. Scartarassi, or in that case, treating the male as the victim. Man takes his ex-wife's or soon-to-be ex-wife's phone, comes into the house late at night. She's only been there in the morning to help get the kids off to school. She hasn't been there on her own before that. She hasn't been there for a week. She's not laying down and sleeping there. She comes there at 1 a.m, disabling the cameras, and comes in. And then imagine a male doing that, sneaking into the home, disabling the exterior camera, sneaking in, crouching down in the kitchen, being caught in lies about whether you had beckoned the dog over or not, and then that he then takes his wife's phone off her sleeping chest, but there's no evidence that he had permission to do that. And he then leaves the house and goes into his car a block away and tries to find out who she's talking to or whatever, tries to access, that guy would be charged. Why? Because it's dishonest and it's criminal. For our purposes here, put aside the criminal for a second, it's dishonest. What Mrs. Scartarossi did is dishonest. And what I would suggest to you what she did is that the police then attempted there's absolutely no corroboration of her account whatsoever, zero. And the only evidence of her account that's been offered today and yesterday and previously are inconsistencies and contradictions. And I would suggest, Judge, that there is no evidence upon which the court should confidently and comfortably bind over. I recognize the burden of proof is low. I recognize that it's only by a probable cause standard, but it's still a standard. And if you start at zero, don't not start halfway, but if you start at zero, so we've got, imagine if you would, like a meter that goes from 0 to 100, and you have to get to 51, or whatever the courts these days interpret as, I know that's a preponderance of the evidence, but they interpret the phrase probable cause, which should have some meaning. Imagine you start at 0. We've got her word, which ticks up a little bit, but then each word, each allegation that she's offered, you've got contradictions and inconsistencies. And on top of that, you've got criminal behavior. I would suggest you get nowhere close to probable cause. Let me add this. I know that the question was asked of the officer, well, do you always arrest people when there's an allegation of domestic violence? And the answer was no. But Judge, I asked that question for a reason. Where there is reasonable cause to believe that an act of domestic violence occurred, you can make an arrest. And the police typically, or I would say regularly do. And in this case, they didn't. Why? Because there's no evidence of it. And on top of that, they want you to bind over not just an allegation of assault with a dangerous weapon, but they want you to bind over on felony firearm. They don't even have a gun in evidence. They don't have a gun, they don't have the gun. Let me posit this to you, Judge. If in theory, if as the state says, and accepts Mrs. Scartarossi's account that in some way that Mr. Scartarossi used a gun in this way, so the police are coming out to Mr. Scartarossi's house. They come out there. He doesn't know when. How would they know when? They drive out to the house. They have every ability to conduct a search, whether it's by consent or whether it's by search warrant, of the entire property, his home, belongings, places, compartments, any place, car. And if they don't have his consent, they can certainly seek to wake you up, which I certainly hope that you wouldn't mind, but I'm sure you've been woken up plenty of times to sign search warrants, and they can wake you up and say, Judge, we've got a case where there's an allegation of a man who is alleged to have committed the crime of assault with a dangerous weapon and domestic violence, and this gun we don't have it. And we don't have reason to believe that he left the house and put it somewhere, which means we have reason to believe it's in the house, or the alleged victim has it. I bet you'd sign that search warrant. And, well, they didn't do that. They didn't seek a search warrant. I would tell you that this is a scary case for anybody that's going through a separation or a divorce. It is incredibly scary that someone can take the stand, admit to a bunch of criminal activity, be as dishonest and I haven't just made the generalization that she's been dishonest, but pointed out specifics about her dishonesty and her lack of credibility on key points. If she would testify that the gun was pointed at her neck and sat here and tried to actually deny what was on the video that we played for, tried to deny that she claimed that the gun wasn't pointed directly, that she denied saying that the gun wasn't pointed directly at her. She tried to claim that she told the police officers, she demonstrated for me that the gun was pointed at her neck, like I'm doing now in some way. You're telling me, and the police officer here testifies, the video shows that's not true, and the police officer testified that's not true, and yet there's a request by the state to have Mr. Scadarrasi bound over based upon that person's word, and I would suggest that that is shameful. And I ask the court to dismiss the case. Now, I recognize, by the way, that if you dismiss the case doesn't end. Excuse me, I should make that an important point for the state to point out. Doesn't end, does it?
No.
All you could do is dismiss counts 1 and 2.
Correct.
And it would leave a domestic violence case before you, which I recognize is all we can do today, is to seek a dismissal of counts 1 and 2, and that's what I'm doing.
Thanks.
Your Honor, I'm not going to lecture you. I'll keep it short. But
You're not going to lecture me?
I didn't lecture you.
I really want to reel it back in, and I want to focus on the third element of assault with a dangerous weapon, which is that at the time the defendant had the ability to commit a battery, or appeared to have the ability, or thought that he had the ability. The defense has said a lot here, and specifically regarding the gun and whether or not it was near her head or pointed. Regardless, these are questions of fact. Whether a gun is near your head or pointed at your head, a person would be reasonable to believe that the person holding the gun has the ability to cause injuries. The reasons why she was there that night are all extraneous factors here. They're all irrelevant, and they are all questions of fact for the trier of fact. They are not relevant here today for this probable cause standard. She indicated that she didn't want him to know she was there and that she had entered that way because she was in fear of him. All of the allegations about her acts and whatever crime that she had allegedly done, first, she testified that they were married, that she had a key to the house, that she was allowed to go there freely. And she testified truthfully the entire time. He claims that she was dishonest. She was very honest, and she said everything she did that night and why she did it. Again, all of these factors are questions of fact for the trier of fact. It's probable cause standard. She testified consistently to what happened that night, and she testified consistently to what she said to the police that night. She said that there was a gun near her head and that she was in fear of her life. Any allegations of her incredibility are questions of fact to be heard at a trial, and we move for a bind over arrest charge.
All right. I always feel like when I start these exams and then they continue 2 weeks later and continues a couple weeks later than that I'm, how do I say it, a little bit at a disadvantage. I mean, I'd like to think my memory is as sharp as it was 30 years ago, but I'm not so sure about that. But I am sure that defendant is charged. We have 3 counts: felonious assault, felony firearm, and domestic violence, and this arises out of an incident which occurred on April the 10th, 2024 in Brownstown Township. And the scene of the alleged crime occurred at, was it 25801 Chelsea Creek Drive in Brownstown. Ms. Scadarrasi indicated that she and the defendant, Mr. Scadarrasi, separated a week earlier, and that she had at that time been living with her mother since she moved out. She had a key to the home and would come there in the morning and get the kids ready for school. There was a lot of testimony concerning the comings and goings of the victim in and out of the defendant's business and the residence that they occupied together until she'd left the week prior. After attempting to access codes from a computer at the defendant's business, which was named, I believe, Silver Touch Landscaping in Romulus, and she did have a key to that business, she then went to the residence again at 25801 Chelsea Creek in Brownstown. And I believe that the testimony was, and I think it's kind of confirmed here, my recollection was that it was sometime initially between 12 and 1 a.m. when she arrived at the business and then went over to the residence on Chelsea Creek. Sometime around 1 a.m. or whenever it was, early morning of April the 10th, she acknowledged that she did disable the security system, that she was secretive and she gained access to his phone. She wanted to delete some spyware from her computer and believed she could do that if she could access the code in the defendant's phone. She drove to the Kroger parking lot after she entered the home and acquired the defendant's phone, and I believe the testimony was she wasn't able to access the code. She returned to the residence and was ultimately encountered by the defendant. She testified that after the defendant observed her, he walked to the end of a table and picked up his gun. I don't see anything in the video to corroborate that or to indicate that that is untruthful. She testified that at some point the defendant was about 15 feet away and he walked through a gate and came up to her, grabbed her in the back of her hair, and placed the pistol under her chin. That was the testimony. She had it pointed, and I specifically asked her, I believe, it was the left side of her neck where she was just indicating that that was in court. She indicated that the gun was a 9mm Smith & Wesson, and that the defendant had his finger on the trigger pointing it under her chin. That was the testimony again in court. She further testified that the defendant said, "Give me my effing money." I'm not going to state the whole word, to which she replied, "I don't have your money." According to the victim, the defendant stated, "I'm going to kill you." And the defendant then stated, "You know who else I'm going to kill?" ? And according to the victim, the defendant looked at the kids' bedrooms and said, "Everyone." She testified that her response was something to the effect that, "You better hope so." The victim testified that she was scared and in fear for her life. The defendant then put the gun back, according to her, in his waistband, pretended he was going to punch her in the face, stopping 1 inch from her face. Their dog, a Rottweiler, then, she said, got excited and jumped on the defendant. Ms. Scatarassi then left the residence and drove to the Brownstown Police Department. I don't think there's any question but that there are a lot of inconsistencies in the testimony here. I mean, you could point out several inconsistencies in her testimony. Some of which may have been or may not have been deliberate. But two facts are clear. No matter how he had the gun pointed, if that's believed, that it would constitute a felonious assault. I don't care if he's pointing it at her neck with the barrel specifically pointing it at her, or if he's waving around the gun somewhere near her head and saying, "I'm going to kill you." Again, all we need is an attempt to commit a battery or a reasonable apprehension by the victim to receive an immediate battery. And then you need an intent to make somebody reasonably fear an immediate battery. And third, also that the defendant had the ability, thought he had the ability, or appeared to have the ability to commit an assault, and fourth, that he used a dangerous weapon. So in my heart of hearts here, I'm very confident that I'm correct in binding over the defendant. There's certainly a fact question here. Credibility issues like this are going to be for the jury. A lot of what the defense points out may very well be persuasive to a jury, and whether the people can prove their case beyond a reasonable doubt is another issue. I will say, for the record, as long as we're talking about credibility, while I found some of her statements inconsistent, she is either one tremendous actress or she appeared to be very credible to me, at least by her demeanor on the video when she was speaking to the police officer. So for those reasons, the court finds probable cause exists to believe that the crime of felonious assault was committed as well as felony firearm. I'm going to bind the defendant over to the circuit court. The AOI date will be 2 weeks, 2 weeks from today, since the defendant is not in custody. And you do not object to the continuation of the bond, correct, counsel?
No objection, Your Honor.
So I'm going to go ahead and continue the bond. If everybody will just give me 1 minute, please. Before 3:18, 3:25. And the AOI date will be on April the 8th, Criminal Justice Center, on the charges contained in the complaint. Obviously, the domestic violence will accompany that. Is there anything else you need to bring up, Ms. Alloway?
Nothing further, Your
Mr.
Honor.
Rockeye?
No, Your Honor, thank you.
Nice to have you here, Mr. Rockeye.
Thank you.
Good luck to you, sir. Thank you. You can go right down the hall and get your notice. Thank you. Thanks. And you just retain the thumb drive then,
Yes.
okay, Mr. Rockeye?
Yes.
Thank you.
Thank you.
Sure.
Have a good day, Your Honor.
You too, thanks. Okay, that guy you introduced.
Oh, I will. I will. I will.
Take care. Good to have you.
Yes, sir. Thanks. Well, next. We'll talk out. Talk outside. Did you go to the front counter for anything, or
The notice.
the notice for the? Okay, thank you. Yes.
For more content like this, don't forget to like and subscribe to the channel.